Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about bail conditions. Cases that should have gone to the Supreme Court of Canada, but didn't. Timothy Lofstrom was charged with a number of offenses in relation to his ex-partner who he had had a tumultuous relationship with that had ended. As a result of these charges, he was released on bail conditions that included not contacting her directly or indirectly. Mr. Lofstrom was subsequently charged with a breach of those conditions when he showed up at a church service that she was also at. He didn't contact her at church, he didn't sit with her, he just attended the same church. He argued at trial on his breach that he hadn't breached his conditions, he'd simply gone to church. After all, he had the right to go to the religious place of his choosing. He was convicted at trial, and his appeals were dismissed by the higher courts. He sought leave to the Supreme Court of Canada, which of course was denied. Mr. Lofstrom's case raises really interesting issues about what actually constitutes indirect contact. Is simply being in the same place as another person indirectly contacting them? Or does it require an actual intention that the person go there knowing the other person is going to be there? Is it indirect contact to be in the same place of worship? And what about a church community, a place of worship that you may be a significant member of, or that may be of very great spiritual importance to you? Can bail conditions impose on a person so that they can't participate in their religious community because of the potential of indirect contact? All of these were very significant issues raised by Mr. Lofstrom's case, and relate in some way to the Supreme Court of Canada's decision recently in Trinity Western about the importance of charter values, including the right to religious freedoms. And the Lofstrom case was an opportunity for the Supreme Court of Canada to just clarify what is indirect contact in a very clear and concise way so that people subject to bail conditions can know. As a criminal defense lawyer, I receive a lot of calls regularly from people who aren't sure whether something they're going to do or they have done constitutes indirect contact. And it would be nice for us as lawyers to be able to point somebody to a clear statement of what is and isn't indirect contact in very recent case law. The Supreme Court of Canada missed the opportunity here and missed an opportunity in a way that also engages with charter interests. Next case that's going to come before them, hopefully they'll hear this and resolve this so that people in Mr. Lofstrom's position don't find themselves facing convictions for breaching their bail orders. You're watching Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Thanks for tuning in to this episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. My name's Kyla Lee. I'm a lawyer at Acumen Law Corporation in Vancouver. Brazen Bull Creative has put together these videos, and I hope you like, subscribe, and share with your friends.